Good afternoon and welcome to today's webinar, New Federal Pay Equity Reporting Requirements for Employers. Today's presenter is Tom Iran. Tom is the chair of the firm's Labor and Employment Law Department and a member of the firm's Management Committee. He exclusively represents private and public sector management and labor relations, employment law, and immigration matters. If you have any questions during the webinar, you can submit them through the Q&A widget located on the bottom of your screen. We will do our best to answer as many questions as possible at the conclusion of the webinar. Finally, please take a moment to complete the brief survey at the conclusion of today's presentation. I will now turn the webinar over to Tom.
Thanks, Kathy. Good afternoon, everyone, and welcome. We certainly appreciate your joining us for this program on the new federal pay equity reporting requirements that are being imposed under the EEO-1 reporting mechanism. I think we all recognize the importance of the topic of pay equity in the recent past and currently. The activity of the U.S. women's gold medal winning soccer team, and not only performing on the pitch, but also we have a little issue with our. There we go. Okay. Bringing their claim for pay equity in federal court against the U.S. Soccer Federation is the most recent and certainly a significant case highlighting this issue. But we've seen these high-profile cases against tech companies, against professional services companies, including several large law firms, against colleges and universities. And in addition to the litigation, we know that at the state level, various state legislatures, including New York State, have taken steps to change the state law rules on equality in pay for men and women and across racial and ethnic groups. This influx of new state laws makes it very difficult for the national employers and for multi-state employers to meet all those various obligations. And lastly, when you think about this issue, you have to recognize that it's ripe for class or collective action litigation, and that just exponentially increases the risk. So that's the background, but today the focus is on the new EEO-1 reporting, which is going to require employers to report pay and hours worked for all of their employees in the EEO-1 format for both 2017 and 2018. And the time to report is now. The EEOC's portal opened on July 15th and will run until September 30th of this year. This reporting obligation, which we're going to explore in some depth here, comes against the background of the federal statutes, and I'm going to focus, limit the focus here just to the federal principles, including the Equal Pay Act from 1963, which requires employers to pay men and women who perform positions of equal skill, responsibility, and effort in the same establishment at an equal pay level, and provides a cause of action for individuals who believe that they are paid less than so-called comparators. And similarly, Title VII, which obviously extends far beyond the pay equity issue, but provides a cause of action where individuals who believe that those who are performing substantially similar work can make out a claim for discrimination if they can establish that pay discrepancy is due to race or gender. And both of these statutes have built into it very specific affirmative defenses for employers, and that is that the employer can show that the pay discrepancy is due to a factor other than sex. For example, a merit pay system or a seniority system or a system that's a productivity system, a piecework system, for example, or any other factor other than sex, then that is a defense to these claims. The EEO-1 reporting obligation that we're talking about arises out of Title VII. Title VII has various provisions requiring employers to maintain records, and part of that record-keeping legislation authorizes the EEOC to collect data from those records, and that's what gives rise to this current obligation. And just parenthetically, I would reference Executive Order 11246, which applies to those of you who are federal government contractors and subcontractors, and you know it imposes additional non-discrimination and affirmative action obligations. And while this reporting of data flows to the EEOC, it is then coordinated with the Office of Federal Contract Compliance, the OFCCP, and available and used by OFCCP in its affirmative action audits and enforcement. So that's the background. And just briefly, I want to talk about how we got to where we are, so the history of this effort to collect pay and hours worked data, right? So this arises out of the Obama administration, several years of review and study and effort to enforce the provisions of federal law in the context of compensation and specifically pay discrimination, primarily as it relates to women, but also significant concerns about the issue of pay equity for racial and ethnic minorities. And the thought was, sort of the driving factor was that the government is looking for additional information in order to identify and remedy these sources of potential discrimination. So the entire program was put in place and approved under the Obama administration, and which included a requirement that it be approved by the Office of Management and Budget. In 2018, last year, the OMB under the Trump administration decided that it needed further review of this issue, and so it halted the rollout of the process. It had already been approved, and this was a directive by OMB to EEOC to not proceed with the rollout. That decision was challenged in court by a couple of advocacy groups, and in March of this year, and that was litigation brought directly against the OMB. So it has a number of interesting issues for lawyers on the standing of the organizations and the Administrative Procedure Act implications of the decision. But the bottom line for us, for employers, was that the district court judge found the OMB action in pausing this process to be arbitrary, and her directive was to the EEOC to put the program into effect. And it was the court that set the timeline based on input from the EEOC as to of the collection of the data. Now, we've seen this process before in other wage and hour and employment-related matters where we've got this push and pull between the Obama administration initiatives and the Trump administration response. And we can hold that sometimes at the 11th hour, we get a court order that says, puts a stay on a proceeding or reverses an initiative that's in place. I can tell you with reasonable confidence that's not going to happen here. While the OMB has appealed the district court's order, it has not pursued a stay of that order pending appeal. And the briefing schedule for that appeal is such that it's very unlikely that the court's going to act before September 30. So with this issue, as we sit here today, it seems very, very likely that the court order is going to continue into effect. And so we are subject to this obligation, which is to report the data for 2017 and 2018 on or before September 30 of this year. So we've got to dig into what this EEO-1 Component 2 directive requires. And let me start with 4 key points regarding sort of the scope of the directive, right? First of all, it applies only in the private sector. While public sector entities are subject to Title VII, they are not subject to this requirement. So municipalities, public school districts, other public employers are not covered under this new data collection program. There are also several exclusions of private sector employers, including colleges and universities. Also, private clubs, private membership clubs are excluded, although labor unions are specifically called out as included. To the extent they could be considered a private membership club, labor unions have the obligation to report this data. The reporting applies, who's covered, right? So the reporting applies to employers that have 100 or more employees. And we'll get to, in a minute, how we count the 100 employees, but it includes both full-time and part-time employees. And then fourth, for those private sector federal contractors who are subject to Executive Order 11246, you know that that applies if you have 50 or more employees and $50,000 worth of federal government contracts. Here, for EEO-1 purposes, only those federal government contractors who have 100 or more employees are subject to this requirement. Those federal contractors who are subject to OFCCP scrutiny because they have between 50 and 99 employees and have more than $50,000 in federal contracts are not covered by this new EEO-1 requirement. You must have at least 100 employees. And that's the group of covered employers. And the period that we're talking about is 2017 and 2018, 2 separate reports for those 2 years. We recognize that, here in the middle of 2019, a lot may have transpired between then and now, particularly employers that went through some kind of corporate change, acquisition or a merger. Think of the situation where a company sold off a business unit, and as part of that process sold off the records associated with the employees in that business unit to the buyer. That's going to create some problems in reporting now in 2019 about what happened back in 2017. And there are some steps that we can take to address those kinds of individual circumstances. I said a minute ago, you've got to have 100 employees. So let's talk about how we determine that 100 employees. And here, the EEOC has given employers, frankly, considerable discretion, right? So employer picks a payroll period in the fourth calendar quarter, right, between October 1 and December 31 of the relevant year, 2017 or 2018, and the employer has discretion as to which payroll period to pick. That payroll period gives us the workforce. It's the so-called workforce snapshot, right? So if you had 100 employees in that payroll period, you are a covered employer. And it is those employees who worked in that payroll period for whom you have the obligation to report. And you can exercise some discretion here, right? So for example, if you're a retail establishment and you normally staff up for the holiday shopping period, you may choose to pick a pay period in October as opposed to, you know, week 52 or the last week of the year or the week of Thanksgiving, when you're going to have more employees and a larger contingent to report on. So you do have some discretion in that, and as my mother would say, you know, that can be a blessing and a curse. I think it's substantially a blessing because you can pick and choose, and if you can pick a payroll period in that fourth quarter where you have less than 100 employees, then you are exempted from providing data because you can establish that as of that date, you didn't meet the requirements for reporting. The curse in it is that when you pick a payroll period other than the last payroll period of the year, the employee complement is not necessarily going to match the year-end data. So you're going to have to sift through the year-end data to focus on those employees who were actively on the payroll during your workforce snapshot period. So that's how we determine whether there's coverage and also which employees we have to report on. You should receive from the National Opinion Research Center, NORC, which is the contractor that the EEOC has an agreement with, and NORC is the entity that is collecting this data. But the system that's in place is for NORC to send employers by U.S. mail and by email an introductory letter which includes access codes so that you, the individual employer, can upload the data into the portal, the web portal that's been established. That portal is now open, and it will remain open until September 30, which time it will close, and no further reporting will be permitted. So I thought the best way to give you a sense of what it is that the EEOC is requiring of us is just to take a look at the forms really at a very high level, right? So this is the classic EEO-1 reporting form, and it requires for the designated population a differentiation among 10 job categories that the EEOC has identified. And individual employers can slot all of their employees into one of these 10 categories and only one of the categories. And at the end of the day, every employee should be accounted for within those categories. And then we would break down the data in each category by sex and race and ethnicity. And the way the EEOC does that is it calls out Hispanic or Latino population first and has us break that down by male and female, and then non-Hispanic, the rest of the population, broken down into one of 6 race ethnic categories that you see on the screen, and report the number of employees in each of those categories. So in that way, again, this is the traditional EEO-1 report. It gives a spreadsheet of all of the employees in the database. What the EEOC has done for this Component 2 reporting is taken that same basic format, the same 10 job categories, and layered on top of that a dozen pay bands, right? So this is intended to account for the full range of potential pay, and we'll talk in a minute about what pay is. And you look at these and you kind of scratch your head about where the numbers come from. And I can tell you they come from the U.S. Bureau of Labor Standards. They have a standard survey form that they use, and the EEOC grabbed those pay bands from that survey. So for every one of the 10 job categories, we now break individuals down into one of these 12 pay bands, and then we go through the same process of breaking those subsets into racial, ethnic, and gender-based categories. So again, we can account for all of our employees in each of the job categories and each of the pay bands. And that, as complicated as it seems, is only half of the process, because now we have categorized all of our employees by job category, pay, gender, and ethnicity. The new requirement adds on top of that we analyze all of those same employees and report the total number of hours worked in the reporting year, 2017 or 2018. So it's a separate spreadsheet, again, broken down in the same multi-factored way, but now it's hours worked. And of course, there's any number of issues that you can think of that come to mind when we try to report hours worked. So we'll get to those shortly. But that's an overview of what the EEOC is asking us to do here in the next 2 months. So let's look at some of the issues that come from this reporting requirement. The first one I think is significant is that there's no linkage back to any prior EEO-1 reporting. No obligation to use the same workforce snapshot that you use in reporting the traditional EEO-1 data for 2017 or 2018. And there is, as a result, no necessary correlation. The individuals that you report on the new Component 2 reporting may be different from those that you reported on under the traditional EEO-1 report, and that's acceptable to the EEOC. We have to report on wages. What do we mean by wages? Well, the EEOC has said we're going to use W-2 Box 1 wages, a fairly straightforward definition, right? At the end of the year, every employee is issued a W-2. It has the total wages earned in Box 1. That's the number that you report or that you use as the basis for slotting individuals into the various pay bands. Now, W-2 wages include actual pay for hours worked, overtime, and pay for time not worked. Vacation pay, holiday pay, et cetera, is all rolled into that W-2 number. Bonuses are also typically rolled into that W-2 number. So that's the wage reporting. The hour reporting, we'll break it down for non-exempt employees, right? We're going to report actual hours worked, and we're going to use the Fair Labor Standards Act definition, right? So that means it's actual hours worked. It does not include paid time not worked. Does not include vacation hours, other PTO hours, holiday hours, etc. And of course, I can see some of you out there scratching your head saying, well, wait a minute. Wages does include that pay for time not worked, but hours does not. Yeah, that's the system that they've set in place. And when we get to talking about the potential for evaluation and statistical analysis of this, obviously is a concern that there's these fundamental inconsistencies in the data. So for non-exempt employees, we use actual hours worked. For exempt employees, you have a choice. You can use actual hours worked if you record that, Or you can use a proxy, right? And the EEOC's proxy is if it's a full-time employee, it's 40 hours a week, and if it's a part-time employee, it's 20 hours a week. Remember that while the data set that we're dealing with is those employees who were on the payroll as of the selected pay week, the workforce snapshot, the data is year-end data. It has to be matched up to those employees who were working at the time of the snapshot. So here's one of the first places that I have some takeaways on what this means for our organization and for your employment practices, right? There's certainly value in taking a look and focus on the data that you have, right? We've talked about using some strategy and picking the payroll period that you'll report from. But beyond that, is our job categories data accurate and up to date, right? We can think of circumstances where an individual, an engineer, a salesperson, at one point had that role and at some point in time was promoted to a supervisory or manager position, and as a result would be moved to a different job category under the EEOC's classifications. It seems to me that there's value in taking the time to scrub that data and make sure that it's accurate as of the time of the reporting. Did the individuals hold the positions that we're reporting on for them? And we have to report information on race and ethnicity. And very often we use a voluntary self-identification system to do that. And I'd raise the question with you as to whether or not you're confident that the system that has been used accurately reflects the racial and ethnic makeup of the workforce. Is this a point in time where we should have a renewed effort to allow our employees to identify race and ethnicity so that our data is as accurate and complete as it can be? What we're reporting on today has much more significant implications for the future than what we reported on in the traditional EEO report. And to my way of thinking, it warrants some further consideration of the accuracy of the data. A couple of side points. Employers who have multiple establishments, the EEOC has a number of different ways of reporting that data, whether you report separately each establishment or you provide a combined report. There is an obligation to report separately for all establishments that have at least 50 employees. But for those with less than 50, there's a couple of options. And there, one of the concerns that I would identify would be if the facility is small enough, although we're not reporting actual individual pay, it may be relatively easy to identify at least the pay band that a particular individual is in. For example, if we're talking about the executive or manager of one site and we're reporting that site separately. As I mentioned earlier, for those entities that have gone through a merger or an acquisition, there are a number of issues that have to be addressed to provide for appropriate reporting. And I suspect we're going to have some questions on that, but I don't want to go too far into that issue in this overview. And then lastly here, I have identified the question of, well, what are the penalties for noncompliance? Interesting, there are penalties, financial penalties, for falsifying the information in an EEO-1, but there's no financial penalty for failure to file. There's no fine, as you see it often under ERISA, for the failure to file reports associated with your benefit plans. The EEOC does have the authority to require an employer to report, and in fact can go into court and get an order compelling filing. But there's no clear financial penalty, and of course, with this system, once the portal closes, you can't report late. But one of the big unanswered questions is, as the EEOC digs into this data, and it determines that there's an employer there that hasn't reported, how is it going to treat that noncompliance? What challenges does that present for us? And particularly, I'm looking here at the context where there is a claim, an EEOC charge filed, and as part of that investigation, the EEOC expects to find EEO-1 reporting, but doesn't. Okay, so this is a lot about the reporting process and what we have to do over the next 2 months to make these reports. But we also have to obviously look beyond that, look ahead to have a full understanding of this new development. So let's start with what we know based on the statements made by the EEOC. And first and most importantly, the EEOC has said that in any case where there is a claim of pay discrimination, whether it's a gender-based or racial or ethnic-based claim, the EEOC expects the investigator to go to the EEO-1 database and to examine the information. The EEOC has very clearly said, we're not going to limit the investigation to the particular job category that is the subject of the charge. So if you have a female engineer, for example, who claims that she is underpaid as compared to male engineers in your workforce, and she ends up filing a charge with the EEOC, clearly the EEOC will look to the analysis of your professional job category pay, but they've also said that they will look at other job categories and may look at all of them. So we don't have detail on the EEOC's intended protocol yet, but clearly this data will allow the EEOC to expand the scope of its investigations. And I have no doubt that the EEOC will independently do some analyses of these databases, and it may then lead them to independently pursue claims, even where it doesn't have a charge from a particular employee. I take a little comfort in the acknowledgement that the EEOC has said that this database is not such that it can identify comparators who are similarly situated, and is not going to be enough to establish an individual employee's unlawful pay claim, either under a disparate treatment or disparate impact theory, or under the Equal Pay Act system that's out there. But it is going to raise the stakes in any EEOC investigation that involves pay equity issues. And I also think if you look at it from the perspective of responding to a complaint, today employers have a great deal of control over the information that gets shared with the EEOC, and we strategically evaluate what information to provide to the EEOC in response to a complaint, even when the EEOC has made a very specific information request. There are risk-reward decisions that we make in conjunction with our clients on what information to provide and how to frame the response. And the fact that this data is out there is going to take away some of our discretion in that regard, right? We lose a measure of control over exactly what the EEOC will have in its hands when it's evaluating a particular pay equity charge. And you know, part of this is I think a response to some of the litigation the EEOC has pursued where it has an individual complaint or a complaint from a particular location, and it's a national employer that is the respondent, and the EEOC has attempted to collect information in its investigation that go to other sites and sometimes across the board at all of the employers' locations. And we've seen the push and pull of that in litigation, and the EEOC has been you know, less than successful in a number of cases in getting the data that it thought it wanted, at least, to pursue its investigation. And those are good cases for employers, but here's a workaround that the EEOC is putting in place so that it already has a measure of data, regardless of what the courts have said and its ability to collect additional data in any particular case. So, what does this tell us about our employment practices today as we look ahead, as we think strategically, right? It adds to the risk of any individual employee taking their claim to the EEOC. And so that means to me that it heightens the value of handling issues internally, of making sure our systems are in place that if individuals are complaining about pay and complaining about being discriminated against because they believe they are paid unfairly or underpaid as compared to competitors, that we are addressing that in the same way that we would address an individual who came and complained about alleged harassment, so that we are controlling the situation. We are responding to the concerns of our employees, and we're handling it internally rather than creating the conditions under which the individual would pursue the claim to the EEOC. And that includes necessarily making sure that our managers and supervisors are attuned and attentive to this, particularly as we get to the end of the year and we're talking to individuals about performance evaluation and their compensation for years ahead, for the year ahead. Are our managers and supervisors properly trained to pick up on concerns that the individuals are making about whether or not they're paid fairly? And then, and we'll get into this more in a moment, but it raises the stakes and raises the value of doing our own internal pay equity audit, so that we understand where the potential issues lie in our compensation system and how that system has been implemented. So these are some of the things that we know the EEOC is going to do with this data. Let's talk about some of the things we have less certainty about, but certainly keep us up at night. Right? And the biggest one here is the potential misuse of the data. And this program, I don't want to get too deep into the weeds on the statistical analysis, but this is troubling in that regard, right? Because we all know that in a well-functioning compensation system, it's a multivariate system. It depends on subjective and objective factors. It depends upon individual management decisions. It depends upon employee decision, employee choice. All of that is wrapped into the resulting compensation. And some systems are very well structured. You think about a collective bargaining agreement, which has a set starting rates, annual increases, often has a pay scale based on credentials or on years of service. That's among the most objective compensation systems. And they vary from that to very subjective ones, and particularly at the highest levels where individual negotiation and individual choice are key components of what the ultimate pay is. These are hard systems to evaluate, and we often use a very sophisticated multivariate regression analysis that accounts for the various components that go into the system in order to develop a model of what pay would be anticipated to be if it was unbiased, and allows us to identify and evaluate outliers that may suggest that there's some other factors at work, including the potential bias. The structure that the EEOC has put into place does not allow us that kind of analysis, right? The job categories and the pay bands are overbroad. They accumulate data in a way that does not account for factors that are very significant. Tenure, years of service with the organization, years of experience, educational credentials, right? You take the job category of professional, and you think about an organization that might have engineers and accountants and attorneys, and to think that those are all lumped together without regard to their particular credentials, it's not likely or feasible. In fact, it's likely to demonstrate disparities and attributed them to bias, when in fact they could be explained by the factors that are built into the pay system. So the EEOC has, recognized statistical tests that they intend to run on the data. My point is simply that those tests are likely to overstate the implication of bias and do not account for all the factors that go into a typical compensation system. So they will mask the effect of legitimate characteristics and attribute it to bias where it's not appropriate. So instead of starting from a clean slate and explaining our pay system, we are now starting three-step stack, because we have a EEOC investigator of, at least at this point, unknown qualifications, evaluating data that is overbroad and inconsistent, right? We recognize that the hours worked and the wages are not consistent, that the hours worked for exempt employees in particular are likely to be skewed. It just makes for an uphill battle to have a non-expert EEOC investigator, having already done this analysis, before we have the first opportunity to even speak to the issue. And of course, these are the concerns with claims that are in the hands of the EEOC. What about those cases that get to are sued by individual plaintiffs, or worse yet, are sued as class actions or collective actions, and the data is in hands of their counsel? Now, I pause there to say it isn't entirely clear that plaintiff's counsel will be able to access this EEO-1 data. There are provisions of the Freedom of Information Act that limit the exposure of data, but generally what we have seen in the past is once a litigation is commenced, if the EEOC has data about that litigation, they will provide it subject to the terms of the Freedom of Information Act. Now, what that has meant in the past is the investigation file for the particular charge that was the predicate for the lawsuit. The extent to which the EEOC will expand that and allow access to EEO-1 pay and hours work data remains somewhat of an open question. But it's a concern. It certainly is a concern for us. And then the EEOC has gone to great lengths to try and give comfort to the notion that unauthorized or inadvertent disclosure, that somehow this data gets hacked, is something that they have under control. My own view is that anything that's on the web, if someone is interested in hacking it and has enough experience and expertise, they can get into it. So great to know the EEOC is putting effort into protecting the data, but I don't sleep well at night knowing that that data is out there and available. Okay. So those are some of the troubling aspects of this. Again, I pull back maybe another couple of steps and look at back to the bigger picture that we started with. There have already been a number of reasons why employers would want to do their own internal audit. And it seems to me that if you're looking at this with a measure of concern and thinking strategically, you're going to revisit this issue of doing your own internal audit, right? So the value of that audit it tells you how your system is working, gives you some statistical information, some statistical data about how your system, your compensation system is working. Clearly will show us aspects, if it's done correctly, right, aspects of legal risks where we have potential exposure. And I would suggest to you in the current environment, in the current labor market, with all the publicity that has come from the high-profile cases, the women's soccer program in particular, that there's value from the employee relations perspective of being an employer who has a concern and cares about pay equity and is taking steps to address that. Now, you're not going to wear it on your sleeve, but certainly internally among the constituents that matter, where you're trying to be an employer of choice, to say that we've done the analysis and we've taken steps to identify and rectify any issues of pay equity or inequity is a strategy for certainly for employers to consider. If you're going to pursue this, you undoubtedly want to do it in connection with your legal counsel. You don't want to engage in an analysis that is subject to disclosure and gives the plaintiff's attorneys sort of a roadmap to challenge your compensation practices. There are legal privileges that exist to protect this kind of self-critical analysis, and it's imperative that if you're going to go down that path, that you do so with good legal advice. Today, different from a year ago, it seems to me prudent that not only to do your own analysis, but to do the analysis of the EEO-1 data, right? that's where the EEOC is going to be coming from. And although it's flawed, we run the audit based on that data. We use the statistical models that the EEOC has said it would use, and we identify potential areas of risk that may be completely unwarranted, but we have to recognize that that's something that is an approach, that is an avenue that the EEOC will be pursuing. So let's be proactive and identify those and either explain them or address them. And that is on top of what would be your own, appropriate analysis using the multivariate regression analysis that fits your organization's comp structure and accounts for the factors that you utilize in your system to help you identify outliers that may or may not be related to bias and to address those going forward. Again, it's a complicated process. We're going to spend some time this fall. We traditionally do a breakfast briefing in the fall, and my thought is that this whole issue of how to do the pay equity analysis and delve deeper into the statistical analyses and how you respond to that, what steps an employer should consider taking, whether it's adjusting individuals' pay or modifying the system in a way to avoid implications of bias or inequity. So we'll talk more about that in the fall. But for now, it certainly is something that I think has to come back on our radar screens as to whether or not this is a strategic exercise that in light of the EEOC's efforts, now has greater value, and because we're facing significant risks. Okay. Jackie, are there any particular questions that folks have asked that we ought to try to address in a few minutes here? And before you answer that, for those who have sent in questions, if we don't get to them here, we'll take a look at them, and we have your information. We will get back to you on the questions that you have submitted. But I wonder if there are any that we ought to present for the whole program here, the whole audience.
Yeah, one question I think is a good one. Do you have to use the 40-hour-a-week proxy for exempt employees, even if your employees are typically excluded to work 35 hours a week?
Well, that's a good question, yeah. And the answer is no, you don't have to use the 40 hours. If you can show that you're scheduling your full-time employees 35 hours a week, you can use that 35-hour-a-week measure.
Another question is if they had 100 or more employees for one of the years and not the others, do they still have to report for both years?
And there, if you're picking up a payroll period where you had 100 employees in 2017, you report for 2017. If your payroll period in 2018, you have less than 100, then there's no reason to report for the 2018.
Another question is, my company has never been contacted to submit EO data, and I know a log-on is required to submit data. What do I do?
Okay. I'm going to respond to that individually because there is a particular website, email address that we can share with you that you would contact.
One question says, Tom mentions that the multi-establishment filers have options for filing Part 2 if they have less than 50 employees. Can you please share that with us?
Sure. Essentially, and again, I can respond directly to that individual, but if you have establishment with less than 50, you can do a separate report on that establishment as well as reports on each of your other establishments, and they'll get rolled into a consolidated report. Or the EEOC allows you to do a consolidated report and then just do a listing of those establishments that are have less than 50 employees. Those are the options that are available in that circumstance. I see a couple of questions trying to ferret out this issue, the coordination between the payroll period that you select and the data that you input. So you can select any payroll period from October 1st to December 31st, and that's the payroll period where you examine your workforce and determine, okay, do I have 100 employees, and if I do, everyone on the active payroll there is the workforce that we report on. But what you're reporting for those folks is year-end data. So you go to the W-2 data, which would accumulate for the whole year. Even if you've picked a payroll period in October, you report for the employees who were active as of October payroll period, what you reported on the W-2, and significantly you report hours worked for the entire year, not just hours worked through the pay period that you're using as the marker. How are we doing on time? We're coming up on the end here.
There's a question. If we have a site with more than 100 employees and another site that has less than 50, should we only include the employees at the first location in the EO report?
Okay, that's a good question. So if you have a site that has 100 plus employees and a second site with less than 50 employees, you're obligated to report on both sites, on all employees. The manner in which you report the data for the less than 50 gives you some variability, but you must report on all employees. We have a question about how you assign individual employees to particular pay bands. Again, that's going to be based on their W-2 wages. So you look at the W-2 box 1, and if the individual has earned $30,000 for the year, it's not going to let me go back. That they would be in the pay band for that includes the $30,000. So it's not the pay as of the pay period that you've identified, but rather as of the end of the year. Okay, I know we have a number of other questions, and we will certainly get to those. Again, I very much appreciate your time this afternoon. We have 2 other webinars coming up in our summer series, both for New York employers. The one next month will include all of the various changes to the New York human rights law. We're still waiting for the governor to sign one bill that's been passed by the legislature there. And then we know this new farm labor legislation is in place, and for that segment of our client base, that the agricultural employers, we'll have a special webinar to talk about the issues raised by that legislation. Again, thank you very much, and for all of you who are clients out there, we very much appreciate your trusting us with your legal business. I hope you all have a good day. Thank you.